We now have before us Senate Bill 1339.
Objections to the application must be filed within 7 days prior to the hearing date. Discovery is not permitted. That's a change. Under the Administrative Procedures Act, you can seek reconsideration of decisions. You can also ask for discovery. Discovery and reconsideration would not be permitted in this process. Appeals must be filed within 14 days, and those appeals must be heard by the Commission within 30 days. Actions taken by the Commission will be subject to judicial review as outlined in Title 67, Chapter 52, which is the Administrative Procedures Act. If no appeals to the Director's decision are timely filed, then it becomes a final order.
Questions for the Director, Senator Sidley?
Thank you, Mr. Chairman. Director Schultz, my question was, I guess, on the appeals process. And I don't know if this is going to be the right term or not, but do you have to have standing in order to appeal? I mean, do you have to have an ownership? Would you have had to shown up at some of the initial hearings in order to be an applicant for that process?
Director Schultz.
Mr. Chairman, Senator Sidway, so a couple things. To participate in the integration process, there is a change in this bill from the status quo. Currently, an interested party can participate in the process, and that's a fairly broad definition. Under this change, an interested party cannot participate in this integration or unitization process. It has to be someone who is an owner, and an owner for the purposes as defined in this part of code means someone that owns minerals. And typically we're referring to the uncommitted owners because those are the folks that have not leased their minerals. If you lease your minerals, the person who has leased them from you becomes an owner. It's a fee simple interest. It's a simple interest in ownership of those minerals when you lease them to someone else. So the lessee of that, in essence, has an ownership right now when they lease it from you. So you would be involving those folks that have leased their minerals, that entity that leased it from them, as well as the uncommitted folks. So those are the people that have a seat at the table in this process, different than the status quo. Now the status quo, it really is up to the hearing officer to make a decision whether or not to allow testimony from currently uncommitted owners. In the first case that we had, that was recently, the applications were withdrawn and the Commission made a decision yesterday, the hearing officer allowed other parties to participate in that process. That the hearing officer could have chosen a different decision. So under the current process, that is a case-by-case decision in terms of who may or may not be led in that process. It doesn't specify specifically in the rules of the code that it has to be one way or the other. Under this change, in order to participate, which gets to your question on appeal, you've got to be an owner. Either you have to have leased those minerals or you have to be an uncommitted owner. Those are the people that have a seat at the table in this process. So that is a change.
Thank you.
Sir. Yes, ma'am.
Senator Hagedorn.
Thank you, Mr. Chairman. Director, I believe you live in the local area. Is that correct?
Mr. Chairman, Senator, that is correct.
And
that is a public record.
Thank you. Thank you. Thank you, Mr. Chairman. I'm wondering, as a homeowner, I'm assuming you're a homeowner, are you and your wife comfortable? Should someone find gas or oil or believe that there's gas or oil somewhere underneath your property, are you comfortable as your family with what's provided in this new time frame where you would have, should you even own your mineral rights, where you would have enough time to have adequate discussions about how that could affect your township where this gas or oil were found? Director.
Mr. Chairman, Senator Hagedorn, I try to anticipate lots of questions. That's not one that I anticipated for this hearing. So my response would be, given my understanding of the process, I would still seek outside counsel to represent me, even if it was me. So I think for an individual that is unfamiliar, or even familiar with the process, I would advise seeking counsel, even to meet these time frames. I think for someone who is not being advised by counsel, it would be difficult.
Okay. We're out of time, but we're going to extend time. And committee, if I know some of you have commitments, and as long as we have a quorum, we'll take testimony for a while. We'll just start down the list and see how far it goes. John Paneth, and please forgive me if I don't pronounce your names correctly. I'll do the best that I can and apologize if I get it wrong.
Mr. Chair, if you wouldn't mind, if I could ask a question. Do you have a time limit or a time certain that we are going to end, or?
Do you have a commitment that you need to be to?
Just to head home.
Okay, well, let's go for 35 minutes here and we'll evaluate then. Welcome to the committee.
Thank you, Mr. Chairman. My name is John Ponath, P-O-N-A-T-H. We live in Middleton. Not real sure where to put this. We want to make the comments on or thank you for the opportunity to comment on the Senate Bill 1339. Just a little insight. This morning, my wife commented that this is very similar to what happened in Oregon at the Mount Hood National Reservation. Is that we're trying to protect our property rights, and we're fighting against the state rather than the federal government. So needless to say, my wife and I are against the Senate Bill 1339 for the following 4 reasons. One, it removes the county planning and zoning authority and grants all authority to the control for the oil and gas drilling with the Idaho Department of Lands and the Idaho Oil and Gas Conservation Commission. Second, it takes our property rights away to control activities on our property by creating a deemed lease, which is their integration process. So if more than 50%, say on a 640 section of land, if more than 340 people agree to sign the lease, then I'm deemed to agree to sign and let them drill on my property. The third thing is that I don't like the section 47.322 that limits my right to discovery for making the names of ownership part of the trade secrets, and it prevents me from getting information to defend my rights of property. So in other words, I can't get the information until after they drill. So there's no way to stop the actual drilling process. And the last item I don't like is the fact that it's created as an emergency act, which means it goes into effect as soon as the governor signs it. We request that your committee send the bill to the Senate floor without approval and without a due process recommendation. Thank you.
Thank you, John.
Thank you.
I appreciate your testimony. Welcome to the committee.
Mr. Chairman, thank you. Members
Pull
of the
that mic
committee.
right down in front of your mouth.
How's
Thank
that?
you. Much better. Thank you.
Thank you for hearing us about this. I'm opposed to making things fast and quick and easy for gas and oil. I don't believe that our state owes them anything. I don't see where gas and oil has really helped any of the states that it's invaded, and I have reason to believe that what I'm going to say to you today is going to seem frivolous. Gas and oil has made my property without value and unsellable. I have a dog training business with 45 acres that I lease. And next door, 600 feet from my property, there's going to be a flare stack there, 1 million gallons of condensate, and a bomb train. And I bet you all of you guys want to line up and buy that from me, because I don't want to live there anymore, because benzene is bad for you to breathe. And I have to live with it, and I've gone through due process. Now what this bill is asking to do is for folks to be told that they have to sell their mineral rights, whether they want to or not. Remember? You were asking about that. This is what happens. The guy shows up, he brings you a piece of paper, and in my experience, this particular guy, Landman, said if we didn't sign over our mineral rights, then all of our neighbors would get ripped off and they wouldn't be able to get gas out of the ground. And like, we don't want to stand in the way of anybody getting their money. They can have their money, we don't want it. We're not in this life to get rich, so we're not like you. We're not like you. We have saved money to buy what we own. We don't have a mortgage. If you have a mortgage, the bank owns your property. What is your property? It's the surface of the ground and it's your mineral rights. If the bank owns it, do you have a right to sell it, to sell it to somebody anyway? You don't. But what's happening now is people are signing away something that they don't have. I have it. I have mine. I paid for mine. I saved 30 years to buy mine. And now my property is worth nothing. And that wasn't even expedited. What's happening with this bill is we want to expedite everything so that they can get their way quicker. And after 1.5 years of fighting this, I'm still going to lose my home. Let's make it quicker. I could have lost my home a lot faster. I don't think that's what we're here for. I think that you guys, like when you started out this whole thing, you wanted to uphold the Constitution. I don't have my own private property rights anymore. Somebody took them from me. I don't get to live in my home anymore because I don't know how to breathe benzene.
10 seconds.
Thanks.
Okay. Commissioner? 3 minutes.
Mr. Chairman and Senate Committee, I appreciate being able to talk to you today. I am the oil and gas experience representative to the the Idaho Oil and Gas Conservation Commission. I've been in this business roughly 40 years, have worked in a number of states. I've reviewed this legislation, have looked at it in light of what I've experienced in other states, and I think this is appropriate legislation for where Idaho is in its early stages of oil and gas. The permitting process in 15 days is longer than other states I've worked in because they're used to processing them. They can process them in 1, 2, or 3 days. The integration process, as you go through it, you get used to the procedures and policies, and those tend to go a little faster. So I find the time frames workable within the state of Idaho, and I think the legislation is appropriate for moving forward with our oil and gas development in the state, taking into account the various interest owners that are involved in it. And I submit to questions.
Mr. Chairman.
Senator Stinnett.
Thank you. With your expertise with the other states, how many of them are like Idaho where they will have one employee, limited staff, and will have to hire hearing officers as an ad-need basis? Is there something comparable, and how many days does it take for them to process?
A lot of the states do have hearing officers. Some of them are employees of the state, and some of them are hired. But the use of hearing officers is not at all unusual. As mentioned before, some of these issues can be fairly complicated, so you like to have people that are knowledgeable of some of the issues and procedures that are appropriate in the oil and gas business.
Mr. Chairman, just right quick, I didn't quite get how many days typically with somebody with a state with a comparable amount of staff and resources, how many days does it take for them to process?
It seems like the ones I've been involved in are 30 to 60 days. You send out the notice to the people who are involved in the unit or in the acreage. They have from a week to 14 days, sometimes a little longer to respond, and then the hearings are set. If it's an adversarial, if there are people not interested or are opposed to the terms of the integration, then that can go before the commission, and usually they're set for the next commission agenda. If it's past a certain date in the month, it may be the following month, so it can vary from 15 to maybe 45 days, depending on the dates that the commission is meeting.
Further questions? Okay. Thank you for your testimony, appreciate it. Stephen Burke. Welcome to the committee, Mr. Burke. The floor is yours. Please identify yourself.
Okay. My name is Steve Burke. I'm a 67-year-old retired veteran. I lived in the same home north of Eagle for 34 years. It's just 5 acres. Doesn't amount to much from what most people would think, but I'm a landowner. I come from Iowa, back before I went to Vietnam, and was introduced to Idaho at the Air Force Base here at Mountain Home. Fell in love with Idaho because I thought this was the freest place I'd ever been. And one of you, I think it was Senator Hagedorn, asked what would happen if you and your wife chose not to participate in a program. I don't own my mineral rights. I only own that 5 acres of dirt that I have my animals on and that I live my life on. I don't own the mineral rights, the state owns them. So I'm told that if somebody wants to drill in my area, I have no say-so. I said, well, if they come up my driveway, they're going to be facing a gun. That is a ridiculous statement, I'm told, that you will have no rights. You would be prosecuted if you tried to prevent the gas and oil company from coming on your property. I don't know how true all that is. All I know is if my neighbor wants to raise hogs, he owns his property. It might degrade my property value. I might object, but I'm not going to, I'm not going to prevent him from doing what he needs to do with his own land. This is a case where, I don't object to oil and gas. I just object to them telling me I have to participate when I don't want to. And the other thing, somebody mentioned a majority, a general majority. Well, we elect you folks because we think that you represent us. We select the representatives that we think best represent us as private citizens of Idaho. And a simple majority is great if we've chosen the right people. And in this case, I would hope that you would say that if a landowner doesn't want oil and gas drilling on his property or in his neighborhood, decreasing the value, polluting the water and air, all these things, then he should be able to say no. And that's what I'm saying to this bill, no. Thank you.
Thank you, Mr. Burke. Appreciate your testimony. Okay, Alma?
remember signing in
You didn't sign in?
No, I don't remember signing in after her. I thought I signed in after Adrian, but that's okay. Thank you, Chairman Bear and members of the committee. My name is Alma Hassey, and I'm a board member with Citizens Allied for...
Now, Alma, need to remind you of the 3-minute limit. Okay.
That didn't count, right?
Nope.
Thank you. I'm a board member with Citizens Allied for Integrity and Accountability. I'm also a small business owner and a farmer in Payette County. And I'm here to speak on Senate Bill 1339 and urge you to vote no on this bill. And because I'm going to assume that you're occupying those seats to represent your constituents fairly and honestly. And so if you're here to do that, then that's why you need to say no to this bill. Here's why. When we're talking about due process, and I'd like to direct your attention to page 2, the lines that are struck from line 37 through down line 50 and continuing on to page 3. Due process is important. I'd like to show you what Alta Mesa's first application that they submitted to landowners in sections 14 and 19 looked like that the Department of Lands accepted I mean, could you read that? I got my reading glasses on. I couldn't read that. And I certainly can't read that. No way. So this is what was sent to section owners in sections 14 and 19, the very first bill. So Ms. Haas sat up here and stood before you today and said that it's everybody's fault because they're asking for due process. Let me tell you what that due process looked like after the Department of Lands accepted that bill. And after we had a deadline on behalf of our members of June 29th, we went and filed our response at 4:30 p.m. on the day of June 29th. An Idaho Department of Lands employee came running down the road after Mr. Warden to say, oh, guess what? There is no deadline date because the application is not complete. We were never notified, even though the department was fully aware of the fact that we were in fact going to file on behalf of our members, nor were any of our members in either of those sections ever informed about the fact that this bill had been withdrawn and was not complete. So that's part of the time. So then, after much hemming and hawing, they refiled their applications, only to turn around days before we were due in a hearing and withdraw them again and resubmit them. That's why that 400-day time frame, and I find it extremely disingenuous that Ms. Haas stands up here before you and represents that it is those mineral rights owners in those sections that caused that delay. That could not be further from the truth. I'd like to...
Time is up.
Of course.
Thank you, Alma.
I'd like to leave this and get it into the record.
You sure may.
Yeah.
Zoe, if you grab that from Alma, appreciate it.
I'm going to give you that.
Adrian Evans.
I actually would like to yield time if I can to some of the folks who have traveled from the areas being directly.
Okay, then give me their names, and I'll be glad to.
Can I go?
Okay, we're going to take testimony from two more folks, and then we've got to wrap this up because we've got other commitments. So please state your name and welcome. We're glad to have you here in our committee today.
Thank you. My name is Janet Herman. I live 2 miles north of Eagle, on the northeast corner of Eagle Road and Beacon Light. And my land is now sandwiched between leased, we are split estate owners at that area. So I've been sandwiched on both sides. So I'm going to get it from the west end and the east end when they start drilling. So I am strongly against passing this bill. It's clearly written to favor the oil and gas industries, our state agencies, and a few wealthy and influential mineral rights owners. This bill does nothing to protect the Idaho citizen and his property rights. In fact, the bill blatantly states that my Idaho government gets to streamline the permitting process, provide certainty to developers, has power and authority to make and enforce rules and regulations, and do whatever it is necessary to carry out the provisions of this act. Bill 1339 would also deprive landowners of any right to appeal forced pooling. I mean, this guy is talking about integration, that's a nice word for forced pooling, and the invasion of their property by oil and gas developers. A private citizen could not seek legal counsel from groups that would offer assistance in protecting their property rights. I have lived in Idaho for 32 years. I've paid my taxes. I've followed the laws. I spent the last 32 years working 10 to 12 hours most of my days to improve my life and my property. I do not understand how here in America, an oil and gas developer can come onto my private property, take my land, set up drilling rigs, build roads, build buildings, whatever he needs to operate, and it is legal. No other business would be allowed to do that. My property value will diminish, possibly to nothing, if he ruins my water. He will pollute the air I breathe, make whatever noise is necessary to run his equipment, and compromise my health. And he gets to do all these activities on my property without my consent, with the blessings and the encouragement of my government officials. Does this sound like America to you, or does it sound like Russia? This has been my belief that our elected officials are here to represent the people they serve, and that these elected officials take an oath to protect the health and the welfare of the general population. I hope that this state that elected you to look out for their interests, not the interests of the oil and gas developers or the elite few who have vast resources of both land, wealth, and influence. And I look at you people, and you are my age or older. I bet you have grandchildren. And if any of you would be willing to let an oil rig on your land and your child or your grandchild be within 200 feet of that oil rig, that's their bedroom, that's their play zone, then yes, you can vote yes. But otherwise, you better vote no. Because that's what you're doing to other people, is you're making them live with this when they don't want to.
Thank you.
Thank you.
Perfect timing, very well spoken.
Hi, my name is Shelley Brock, and I have lived in Eagle for over 4 decades. I'm a full-time healthcare professional. I'm a devoted mother and grandmother, and a longtime Eagle small farm and owner and taxpayer. My home is right next door to several large state-owned split estate tracts of land that have already been leased for future drilling and fracking by Alta Mesa for natural gas and oil. I and many of my neighbors are going to be directly impacted by the forced pooling that you guys are considering this bill on. They will use the state-owned lands to force pool us when they need to. So Senate Bill 1339 will directly adversely impact me if it is passed into law, as it will all residents of the state of Idaho. I ask you all to look me in the eye as I stand here and tell me how you can ethically, morally, and legally pass this bill, considering that it will strip Idaho property owners of all due process and the ability to fight for our civil and property rights. Consider that it will inevitably force the vast majority of us into technical default of our mortgages and will almost certainly cause the cancellation of our insurance policies. I know that you have all seen the same letter we have from the Attorney General's office, the legal counsel for the state of Idaho, proving that this is true, that it will affect mortgages. And knowing those facts, I want you to tell me how you can even consider passing this egregious bill. Why are we even here today contemplating something that will so profoundly impact the private property and civil rights of the very constituents that all of you so publicly proclaim to be champions of? It is the epitome of hypocrisy that a bill like this could be drafted and implemented by the very state officials who have taken an oath to protect the health, safety, and welfare of the citizens of Idaho. Are you really going to allow this predatory industry, and that's what they are, to dictate legislation that will turn the Treasure Valley and the rest of the state into their next sacrifice zone, as they've done in over 36 states across this nation, with poisoned air and water and a backlog of lawsuits against public health, civil and property rights, and decimation of property values, just so that they and a handful of big property owners can profit? Are you really going to force us to negotiate what is an acceptable level of benzene for our kids to breathe and an acceptable level of methane to have running through our water pipes? Are you really going to imperil our state's lifeblood, her profoundly precious, irreplaceable water aquifers and surface waterways, by enabling this industry to remove and destroy untold millions, even billions of gallons from these outlets for their production needs? It is your responsibility as the people who are governing now and for future generations to protect this place, not for just some people, the oil and gas industry, and a handful of wealthy landowners and public officials from the state level on down, who stand to profit by your actions, but for all Idaho residents. You and the rest of our officials from the highest office on down have taken an oath to protect our health, safety, and welfare. We are here today to hold you accountable for that oath that you took with one hand on a Bible and one hand outstretched to God, promising to protect the very people who have elected you.
Okay,
I trust you will remember that vote. No on House Bill 1339.
Thank you.
Thank you.
Oh, we have a question for you, if you wouldn't mind. Senator Vick.
Earlier in your debate, you referenced fracking, and then you referenced a couple of other things to fracking, and I'd like for you to point out to me how anything in this legislation addresses fracking.
Well, Mr. Vick, Senator Vick, the industry and members of the state have been very careful to smooth over the fact that there is going to be fracking here, but we can show you mountain of evidence to prove that they will eventually treat, stimulate, frack these wells. It has been written into the legislation, and I'm surprised you don't know that. It has been legislated to allow them to do this here. We have past records proving that in applications from their predecessor, Bridge Resources, they applied and said they were intended to frack.
Mr. Chairman, is there anything in this legislation that changes what can be done in regards to fracking in the state of Idaho?
I don't know that anything in this bill addresses
the
whether they're
bill-
going to
that's the
conventional
bill we're
drill or
dis-
frack.
Excuse me, I'm sorry, Mr. Chairman.
Thank you, Senator Vick.
Does that answer your question?
Well,
Vic?
generally we try to contain the to what's in the bill. I don't think there's anything in this bill that relates directly to fracking, and so I just
Actually,
want,
I have something here. Section
Please-
47320
Please address the chair.
specifies it.
Please address the chair before speaking.
Oh, I'm sorry.
Thank
This is my first time in front of
You're
you
doing great.
folks, so pardon me.
You're doing great.
Senator Bear, Senator Vick. Section 47320, permit to drill or treat a well. Treating means stimulating the well with different chemicals, including fracking. You can read further into that and it explains it more.
I don't believe that's correct, but and that's also that's existing law.
Well, I would like to invite you to the State House here March 7th. We're going to put on a forum and have some experts that will teach you all about that. We hope you'll come.
Thank you for your testimony.
You got it.
Oh, Senator Hagedorn.
Thank you, Mr.
Shelley,
Chairman.
come on back.
I apologize.
That's all right.
You had also mentioned, I appreciate the question from Senator Bishop. I was going to ask the same thing, but you had also mentioned an Attorney General's opinion, and you assumed that we had all seen that, and I have not seen an Attorney General's opinion.
Oh, well, we can forward you that too, probably. I thought that you all had seen that.
I have not. Thank you.
Okay,
Thank you.
So you have seen it? Correct.
no, he has not.
Check your map.
Ms. Hawes, would you like to come sum up?
Chairman Bear, and the 4 words were allowed an extension because there were so many people who needed to testify. Why are you not able to do that? Excuse me.
We've extended, we've got travel commitments, and we've given ample time. This is the ruling of the chair.
This process is a fraud.
There are still people here who have not testified.
I traveled here.
I came from them.
Ms. Hawes.
Can we extend it another day or two?
We have schedules on Monday and Wednesday that are all scheduled. We'll continue.
Chairman, members of the committee, I do want to address a couple of questions that came up, perhaps add some color. There are a couple of different questions about workload from Senator Lacey and Senator Stennett. We've discussed that extensively with the department and recognize the department's need for proper resources. Director Schultz, I think, told you all that they could process about 2 to 3 applications a month for the more intensive applications. We don't anticipate filing more than what they can handle until there's funding for the program such that they could get additional resources. So I think we're comfortable with what he can handle and the timeframes laid out. I think that's why both parties are comfortable. Secondly, as far as the 400-day estimate, we agree with the director's estimate at which point you get to a hearing, that it would take about 6 months to get to or through a hearing. Our estimate comes from the incorporating also all of the appeals period. And we use 400 days because we're trying to make an apples to apples comparison. So that's where the 400 and 100 come in. It's 400 for an appeals period to run out, and where under this proposed bill it'd be 100 for an appeals period to, or 107-ish for that same period. I do want to revisit a couple of things very quickly. Mr. Warden very much confused royalties and what a working interest owner is. First off, I'd like to state that most of the points that he raised to you are policy decisions that have already been made. The things that he picked out of the bill were simply pulled from rule. Those are already existing. But additionally, on the working interest owner option, that is someone who gets the 1/8 royalty. Now, unlike what he stated, a working interest owner is entitled to the 1/8 royalty from the get-go, just like everybody else. Yes, the working interest owner does, it's taken from the pro rata share of costs out of the 7/8, that's called the working interest. His pro rata share of the costs is taken from that 7/8, recovered from there, so that the working interest owner doesn't have to pay out of pocket. And then there is the risk penalty applied to that 7/8, since that working interest owner didn't put forward any money for whatever reason. And then after such period that risk penalty is applied, the working interest owner not only gets his 1/8, just like everybody else, but he also then gets the 7/8, which is a pretty big distinction from what was presented. So I want to clear that up because, candidly, I just want to make sure there's no confusion about it. Additionally, the 1/8 royalty that you see throughout is, again, what's already in rule and what's standard. Beyond that, I just want to say thank you all very much for your time. We appreciate the testimony of everyone who came, and that people are so interested in this topic. And with that, I would ask for a due pass recommendation.
Okay, any discussion among the committee or motion would be in order? Senator Sidaway?
Mr. Chairman, I move that we send 1339 to the floor with the due pass recommend.
Second.
I have a motion by Senator Sidaway, a second by Senator Vick to send Senate Bill 1339 to the floor with a due pass recommendation. Is there any discussion on the motion?
Mr. Chairman.
Senator Vick.
Yeah, just briefly, because private property rights have been addressed so much, and I'm a big believer in private property rights. But I think that all people who have property rights need to be considered. And it seems to me that what's being said here today is if it's in your interest, you own the property, and it's in your interest to drill or to extract those mineral rights, your property rights are not worth as much as people who do not want to extract those minerals. And I just have a real hard time with that. Also, we heard that no good has come from the oil and gas industry. And I don't know how any of you people got here today, but I drove. And so I do feel like some good does come from the oil and gas industry. And it's just hard for me when we're just getting part of the story. And I just wanted to make clear to everybody that private property rights are very important to me. I do think that this does a reasonable job. There's no perfect way to do it, but this does a reasonable job of protecting both the rights of those who would like to have access to their minerals and those who would not, and I will be supporting the bill.
Senator Stinnett?
Thank you, Mr. Chairman. I do commend the effort so far. I think this was our 7th revision to get us to this place. But I still have a few outline concerns. I know that we've been talking about the department would be able to handle what potentially will come to it with existing conditions, but as we've heard all around the states, the oil and gas exploration is expanding rapidly. I know that there are now new areas in Twin Falls, and as we find more places to explore, that is going to exponentially increase. So I still have a problem with the limited staff and budget. And I'm still not clear in this bill what direction the Department of Lands has as a recourse if it's unable to meet its deadlines. And so the statute, it needs to be considering the future, not just the present. And I'm not sure that it is addressed giving any kind of latitude to the department if it can't meet its requirements. It also removes those that aren't mineral rights to have any standing and impact. That are impacted, as we've heard, and so that concerns me, understanding that perhaps it isn't the entire state that needs to weigh on a single area, but at least those that are impacted should have that recourse. And eliminating the contested case hearings replaces the burden to the owner to litigate rather than the commission doing the contested case hearings, which I think is an unfortunate burden to the landowner from current process and procedure. And finally, they redacted confidential information that these potential leasees receive isn't adequate. Is the mineral rights owner getting the best information to make the most educated decision? I think they get a very reduced amount of what they can operate off of and to make a decision, which is important to their land and to the rights of those mineral owners, and that also regrettably isn't clear in this, and so I will be opposing the motion.
Senator Hagedorn. Thank you, Mr. Chairman. I too, like Senator Vick, am very concerned about property rights. And I think one of the things we need to also consider is the dirt that you live on is one type of property, but the minerals that are underneath that property are another type of property. Both are personal property should you own those. So finding a balance between the dirt that you live on and the minerals that are underneath that soil, that's the struggle for me. I don't right now believe that we've got the language that is sufficient to take care of the property rights for that soil that you live on. But I do believe that we've addressed the minerals underneath that soil. We're struggling, I think, as a new state getting into this business, trying to do the right thing and trying to find the right words to allow all the property rights to be properly protected and utilized. When you stick a straw in the ground, like in a glass of water, you're affecting the minerals under other people's soil property. And trying to find how that's fair is a tough thing for us to do. We've got to look at other states and what other states have done, the remedies that they found through the courts. We're not old enough in this business to do that yet. We've worked on this, I know, for quite a number of years. We've got really good regulations for fracking, yet that's not occurred yet here, and would be a different permitting process and would double the cost of drilling, which would probably slow the cost of drilling should they have to do that. But we've tried to look forward enough to understand that we've got to protect our aquifers and our water, and I think that the people that are working here, the Alta Mesas of the world, the folks in the Department of Lands, we all live in the same area. We don't want to hurt our water. We don't want to make that, we don't want to allow that to happen. And I think everyone has got the best interests in heart. Is this a perfect bill? It's not. But I think every time we make adjustments to the language, we make it better. And I suspect we'll see modifications to this bill come up again next year to make it even better. But we've got to move forward. We can't allow a company or the Department of Lands not to be able to forecast within the next 365 days of their business cycle. We can, as a legislature, manage the Department of Lands budget if we don't understand what's going to be happening in the next 365 days. And right now, we've got a process that runs out over 400 days or longer. I would not want to be in a business. I would not want to have to run my business with my P&L and try and forecast my P&L 2 years out. That's a hard way to run a business. So we've got to move ourselves and be more compliant with the other states that we're competing with to utilize the resources that we have here. The Wyomings of the world, the Alaskas of the world, the North Dakotas of the world, they don't have trouble funding their education system. And they don't have trouble funding their education system because they properly utilize the natural resources in those states. I think we need to get there. We need to figure out how to get there. We all want better education system, but we've got to figure out how we can manage this properly and get to that point. Thank you, Mr. Chairman.
Senator Sidway.
Thank you. Just for a moment, Mr. Chairman. You know, for you folks that live in that area and are going to be affected maybe more than the rest of us, I truly appreciate your individual testimonies, and believe me, just one or two of you speak on will have 10 times more influence than any hired gun you're going to send in here to talk to us. This is difficult for everybody because we do need the jobs in the industry here. We don't want to send our children to some other state to work. Anyway, I don't. We've taken primacy. In fact, we just did some bills today on the floor. The state takes primacy over our underground storage tanks. The state takes primacy on our water emissions. The state wants to take primacy. We think and we see where we've taken primacy on some of these issues. We've increased compliance. We've lowered the fines. We've done a better job with that outreach. And we certainly admit on the initial legislation that we made mistakes. We thought that the commission could handle all of this, okay? The commission thought they could handle it too. They met 4 times a year. And then the applications started to come in, and they started to have to meet every 2 months. And then more came in, and they had to meet monthly. There's too much of an effort coming for just the commission to handle it. And this is just like every other state agency. There's a lot of agencies, and Fish and Game is one that has a commission over it. They work on the policy, but the department is actually who implements it. And now we've evolved to that situation here. And think how frustrated you would be if you went in and wanted to build a garage on your house and it took you 1.5 years to get an application. You know, so it's are we going to do it at the state level, or are we going to figure out something else? So I understand your fear and your frustration.
You don't. No, you don't. It's not in your backyard yet.
Anyway.
Let them drill in your yard.
Okay, so question.
10 feet from your front door.
The question has been called. So there can be no further discussion. All those in favor say aye.
Aye.
Opposed say nay.
No. We don't have one nay.
Would you like to be recorded? Okay, Senator Stennett will be recorded as voting nay. The majority haven't voted in the affirmative. Senate Bill 1339 will be sent to the floor with the due pass recommendation. Thank you all for coming. We're dismissed.
Welcome to the United States of Russia. Vote now.
What about the tax base, you know?